Hi everybody, this is Arkady Frekhtman. I'm a New York City personal injury trial attorney, and welcome to Last Week Tonight, where we answer your questions and we talk about your comments. It's all about you, the viewer, on this episode. So let's get into it. Here's the most recent comments, and today is January 2nd, 2025. Happy New Year, everyone. And this is the most recent comments on our channel. 3.5 million for slipping on snow like that's anyone's fault. The reason everyone pays so much in taxes is because of leeches like this. What a horrible drain on society these people are. So you see, like, some people don't like the idea of slips and falls. So as a trial attorney, what you have to do is you have to bring that out in jury selection. When you're picking a jury, you don't want one of these people, like this guy, his name is Machinist number 7. You don't want one of these people on your jury, right? Because no matter what the evidence is, no matter what evidence you show, even if you show that there were safety violations, that they had a dangerous condition, that they knew about the dangerous condition, they chose not to fix it, he's still gonna say, oh, you slipped and fell, you're just, a leech on society. So, it's very, very critical to pick the right jury, because some people just don't believe in certain types of cases, whether it's a bias against motorcyclists, right? A bias against slip and falls or any other types of case. So everyone's entitled to their opinion, but this particular case that he's talking about, actually it was the opposite, because there was like a staircase with, I think, like 50 steps, a really long staircase leading to an above ground subway. It was metal, and it had snowed, but it stopped snowing, and they had a crew of 10 people there. They actually had the shovels and the saw. They knew they had to clean it. And the supervisor told them, hey, you know what? It's more important to go to another station. So they all picked up their shovels and their salt, and they all left, and they went to another station. Meanwhile, nobody cleaned these stairs. So these stairs were left to the elements, and there was a roof above it, but it was open on the side. So the snow and the wind and the rain blew in, and there was ice. And then as our client tried to be careful, hold on to the handrail, did everything a reasonable person can do, but he still slipped and he went all the way down. And then he ended up having a bad neck injury with a serious fusion surgery. And then we ended up settling that case during trial for 3.5 million. But I could see, yeah, some people just don't like these types of cases, but that's fine. I wish everyone a happy new year, and I wish you all the best. But I think that really illustrates the importance of picking the right jury. Because if you're a trial attorney and you get one of these people, like, just doesn't believe in slip and fall cases and thinks like, oh, if you're bringing a case into the legal system, then you're like a leech on society, or you're trying to steal from others. That's actually good for you, right? Because you've uncovered them. It's worse if the person doesn't say that, right? But they're really thinking that, and then they make it onto your jury, because now you're just not going to be able to win the case. So it's actually a blessing to find one of these people. So you want to be thankful and grateful for finding them, because then you can get them off for cause, and then you have a fair and impartial jury. Here's a question from me321Z. Here she says, I signed a consent after the doctor told me he's using a synthetic product to fix the knee, and he unknowingly uses human product because he's not educating himself. The product was not a necessity, and it caused me harm in further operations. Is that punitive on top of malpractice? Can the insurance get out of paying compensatory because the doctor was reckless? So, yeah, first of all, you want to be able to show that there was any kind of medical malpractice. So you have to show what the doctor did wrong. It's basically medical negligence, or, there's basically like what you would call good and accepted practice, right? If this is good and accepted practice, then the doctor has to fall below that, and that's a mistake. Didn't even uphold what's good and accepted practice, kind of like the lowest common denominator. But his work wasn't even to the lowest common denominator, it was below it. Now, punitives, a lot of people talk about punitive damages, but punitive damages is really to punish either the doctor or the company for something that was like so malicious, so evil, that he knew that it was going to hurt other people. So it says in the beginning it was unknowing. So if he did something unknowing, most likely it won't be punitive. Punitive is usually when you do something that you know is likely to hurt people, but you do it anyway because you just don't care, or because you want to make money. So it's rare, especially in New York. It's very rare to get punitives, but you can. And then the insurance company, I don't think can get out of it, right? If there was a mistake and he has insurance, you should be fine. But I would definitely recommend consulting with a local medical malpractice trial attorney. And if you need us to help find an attorney, or, we handle medical malpractice cases as well here in New York. So you could always just text me. It's 347-566-9595. And we're happy to do a consultation. In fact, today I did 2 consultations, and one of them was a medical malpractice case here in New York. So we did a in-depth consultation about that. And then I did a consultation about a truck crash that happened in Georgia. We talked about that case and all the injuries and all the liability and all the scenarios. So yeah, I'm happy to do those. And then what's new says people watch too much YouTube. The client at times thinks they know more than the lawyer. If that's the case, represent yourself and see how you do. Plain and simple. If the at-fault driver has a horrible insurance, you're going to have a horrible outcome, especially if you yourself have a bad policy with no underinsured to back you up. Yeah, I mean, that's true, essentially. And he's talking about my video, recent video called Why Rushing Your Settlement Could Cost You $900,000. Don't suffocate your case. And I was talking about a particular client who was like, I want my case done now. But the case, you can't just go like that, right? And make it done now. I kind of compared it. There are a lot of different analogies, but I think I compared it to like a flower, right? You put the seed, the flower starts growing, but it hasn't grown yet. It hasn't opened up yet. There's no rose. So you could pluck the flower, but it's just a little green stem, it's too early. So it's the same thing with cases. And, sometimes I think most clients are good. Most clients do listen, and most clients are good clients. But I think there's some truth to this comment that maybe because people watch too much, or they think that they know more than the lawyer, and sometimes they try to micromanage their case, or they tell the lawyer what to do, and then it could actually end up hurting the case, right? Because the lawyer knows what they're doing, that they're the professional. Just like when you go to a doctor, right? You're not going to say, oh, doctor, you don't need the number 2 scalpel, you need the number 4 scalpel. No, the doctor knows, he's doing the surgery. You're not going to tell him what scalpel to use or whatever, what instrument to use during the surgery. It's the same thing here. So you have to kind of let the lawyer do their thing. But of course, you want to have communication and you want to be involved. And Ricardo says that his wife died from pancreatic cancer and liver cancer, and she was taking Zantac. Oh, I'm sorry to hear that. That's terrible. And yeah, definitely reach out to a Zantac injury lawyer. You can reach out to me. I know some lawyers that I'm partnering with that are handling Zantac cases, and I was handling a few of them together, so I could help with that. Here's a question from Miguel. He says, good afternoon, Arkady. After 3 years and 3 months, 5 surgeries, including 2 fusions in the lower back, I already want to close my case and not have more medical visits, in which time I know I could close my case. And if it's prudent, send a letter to see if we can reach an agreement or wait for court. But I don't have a court date yet. Yeah, so I mean, that's good. The lawyer has to be on board with you. So speak to your lawyer and make sure that if they think that everything is ready, it's been a long time, right? 3 years. So absolutely, if the lawyer can send a settlement package with all the information, I like to do a settlement opportunity letter and say, look, there's 5 surgeries, pay us X, whatever the number is, 3 million, 5 million, you have 30 days, here's all the evidence. If there's anything else that's missing, let me know, I'll provide that. So I want you to have all the information so you can make an informed decision, and here's your chance to settle it for this number. If you don't, that's fine, but when we go to court, it's not going to be this number anymore. It's going to be probably double or triple. And then that kind of puts them in a corner and you have the upper hand in the negotiations. So yeah, I told the person also to text me if they wanted a personal consultation. It's 347-566-9595. 650 Tony says, when is it too late to fire your attorney? I mean, it's never really too late. I mean, ideally, you'd want to just hire the right attorney right from the beginning, right? You don't want to be firing attorneys and switching attorneys. But if you have to, it's never really too late. Like last year in 2024, I could say last year because it's already just been 2 days in 2025. But I believe it was, 2024, we did a case where somebody switched when the case was already on the trial calendar. and the case was like pretty much done. And we took it over, and we were able to, significantly increase the number. I think we went from an offer of something like 100,000 all the way up to 600,000 in one case. And then in another case, there was an offer of maybe like 500,000, and we went all the way up to like 1.2 million. And both of those cases were on the trial calendar just a few months away from trial. So you could always do it, but remember, the incoming lawyer, meaning the new lawyer that's going to take the case, may not agree to take the case because now they're not going to get paid very much, because the first lawyer is going to say, well, I want the legal fee for all the work I did, and then they have to share that legal fee. And one of the factors is how long you've been handling the case. So if the one lawyer has been handling it for like 5 years and the new lawyer comes in and only handles it for a few months, the first lawyer may be entitled to most of the legal fee. So then the second lawyer might say, you know what, it just doesn't make sense for me financially to do all this work and just get paid very, very little, almost like pennies on the dollar, right? So that might be an impediment, the lawyer not getting financially compensated. But other than that, I think you can do it pretty much at any time. And then the same person says, I'm sick of my lawyer not communicating, but then recommending all these other doctors. Too many irons in the fire means less money for me. Yeah, I mean, that's true. You don't want the lawyer not to communicate. Communication is key. And also, I mean, recommending doctors is good if it makes sense, right? If the doctors are giving you medical care, it's the right treatment, it's leading to some kind of case result, where you don't want to just be recommending doctors so the doctors and get paid, or they're doing some procedures and they're going to put upon liens on the case or get paid. But then, if they're not going to help you, if you don't need these doctors, what's the point? Here's a question. My mom had a stroke while she was in the hospital, and no doctor came or called when requested at the time when she had left-sided weakness. It wasn't until 14 hours later that a physician's assistant decided to show up and then found that she had left-sided weakness, and at that time decided to do an MRI. Indeed, she was diagnosed with a stroke to the right brain. If the doctor had responded right away, the damage would not be as severe. But unfortunately, this did not happen, and nobody wants to take responsibility, and no attorney wants to take the case. Who can I consult with? Who is able to help? Yeah, just text me, 347-566-9595. I think this person may have texted me. I'll follow up and maybe do a call later today. Yeah, absolutely, because that could be a good case. Actually, there was a case like that I did a video about, where they were only a few hours late. But because of that, with these stroke cases, time is brain. So even a few hours could make you potentially like permanently brain damaged. And I think that case went to verdict for like $120 million. So they could be very big cases. Here's a comment. Clients might be going through rough economic times, maybe no work due to injuries and need to pay bills. Clients should be patient for a good outcome. Yeah, absolutely. I mean, that's the thing, like you are going through rough economic times because you got injured, you can't work, but you have to be patient, because there's no way to just make the case give you value. You have to, prepare the case the right way, and then when it's ready, then you kind of like, just like when the flower, right? When the flower blooms, the beautiful rose is there, then you pluck it or whatever, you put it in your bouquet. You don't do it early when the rose isn't there, right? So it's the same kind of thing. Here's a comment. Never settle for less under any circumstances, especially if you've been waiting years already. That's true. You don't want to leave money on the table. And then Nodorant says, are you seeing an increase in this behavior, also referring to rushing a settlement now, or was it always like this? Well, I would say like it's always been like that. Not necessarily, I'm not saying like everybody's doing that. I'm just seeing like a few people. It happens with some clients. It doesn't happen with, I mean, most people are patient. Most people do the cases the right way. It's just I'm seeing it with, I would say I'm seeing it more now than I was a few years ago, or even many years ago, but I'm seeing it with a few people. Cornelius says, in response to the video, 5 critical steps to winning justice. That was a great video. Thank you for sharing that video. It made me and my family say that we've made a very good choice hiring your firm to represent my case. Thank you so much. Oh, thank you. No, I'm really happy that you're happy. That's what it's all about. Keeping the clients happy, doing a good job, getting a good result. And then Corey says, ceiling fell on someone I know. They had multiple MRI and CAT scans, tears in both knees, 2 tears in the shoulder, 1 in the left. or 2 tears in the right shoulder, 1 in the left, and a bulging disc in the spine, 2 steroid injections, a lumbar epidural injection, and they've been going to therapy. Doctors are saying they need to do arthroscopic knee surgery in both knees to repair the tears, and also surgeries for both shoulders to repair the tears. With everything that's going on, what do you think the case is worth? Yeah, so I mean, if the ceiling collapsed and you have good liability with that, like notice and prior complaints, then I think you have 2 knee surgeries, 2 shoulder surgeries, so for 4 surgeries, that could be significant. That could even be over $500,000 into possibly even $1 million or more. I'd have to, of course, speak with the person and do a little bit of a deeper dive, but just from what you're saying, it definitely could be a high 6-figure, possibly even 7-figure case. Here's a question. Can you still get a settlement after a letter of conciliation says planned future action with active 100% payment going? From my understanding, the case is basically closed with payment until I heal. I had epidural and another 6 weeks of PT added. Yeah, I'm not sure about that. That might be some other kind of case. You're talking about a conciliation. It might be like some kind of workers' comp or some other kind of disability case, because with personal injury, we don't really have that conciliation letters. So you could always still get a settlement in personal injury. Workers' comp would probably depend on your local jurisdiction. Someone says that will get him like $25,000. All right, because the client wanted to just kind of force a settlement now and say, look, give me an offer. You got to remember, like, it's not really about getting an offer. A lot of people think like, oh, if I have an offer, I have something, right? But it's not really about an offer. It's more about like what the position of the case is and how you're approaching it and how you're preparing the case. Because if you're just looking for a quick offer, the insurance companies, they're sharks. They're going to smell blood in the water and they're going to say, oh, they're just looking for a quick offer. So give them a quick offer, like $25,000, exactly. But you don't want that. You're trying to get the case that I was thinking of, this particular client, we're trying to get like $400,000, right? Or $500,000. So we don't need a $25,000 offer. And it's really crazy because like I see the answer so clearly, because I've been doing this since like 1999 for almost 26 years now, right? I've been doing this such a long time. I see the answer, I see what's going to happen, but the client, some people are just stubborn and they don't want to listen to good advice. So, it's unfortunate, but what can you do? Here's a question, an extremely good video. Being a client and this being my first time, a lawsuit, the emotions run high. I may be looking at a 100K limit, but I'm certain an asset search will show they have significant assets, including an LLC. So my intent as of now is to go to trial, and I guess let the discovery show the best way to go. Yeah, I mean, you could do that. You can go to trial. I mean, make sure it's collectible. Like if you get more than the 100, if they have a 100 limit, make sure that if you get more, if they have assets, it's collectible. But the lawyer should be able to check that. And here's a question. I was in a bus accident and nobody has contacted me or talked to me. And the lady across from me that was also in a wheelchair, we both flew. I was between my wheelchair and the metal pole and the metal bench. I don't know how I ended up taking a pic of the lady across from me as she was getting ready to fly out of her wheelchair. Yeah, no, I'm sorry to hear that happen. I mean, yeah, feel free to text me also to have to speak with you and see like what happened and how, if we could help. Usually with a bus accident, it just depends on how it happened. If the bus obviously hit another car, the bus could be at fault. The other vehicle, whether it's a car or truck, could be at fault. Sometimes buses just stop short because it's dangerous and a car cuts them off. And then people fall inside the bus, and that could or could not be a case depending on the factors. Sometimes if he had to stop, right, because the other option is to crash into the car, then stopping short, even though it causes someone to fall, could be reasonable. But other times bus drivers just stop short or do crazy maneuvers where there's no justification for it. So it just depends on all the facts and circumstances. Okay, everyone, thank you so much. Please like and subscribe to our channel. We are here for you. Our goal is helping serious injury victims and families, and all the best. Bye-bye.